Harvard versus Trump. The battle over federal funding and university policies. In a high-stakes legal showdown that could have far-reaching implications for both higher education and government policy, lawyers representing the Trump administration and Harvard University are set to face off in a Boston courtroom. And this is the part most people miss. The outcome could influence billions of dollars in federal funding and reshape how universities operate in relation to government oversight. The White House has frozen over $2 billion, £1.5 billion, in federal grants to Harvard, demanding that the university overhaul its hiring, admissions, and teaching practices. The administration claims these changes are necessary to combat antisemitism and to put an end to diversity, equity, and inclusion (DEI) programs, which they argue are divisive or problematic. But here's where it gets controversial. Critics argue that these demands threaten academic freedom and free speech. Adding fuel to the fire, the Trump administration has also taken steps to block Harvard from accessing a visa system that allows the university to enroll international students. This move could significantly impact Harvard's ability to attract talented students from abroad. In response, Harvard has filed multiple lawsuits, seeking a swift legal resolution through a summary judgment, an expedited process where the court makes a decision based on the facts presented, without going through a full trial. The upcoming hearing, scheduled for Monday, will be presided over by U.S. District Judge Allison Burroughs. She has already issued several interim rulings favoring Harvard in a separate case concerning the foreign student visa system. While a quick decision after this one-day hearing isn't guaranteed, Harvard's legal team has requested a ruling by September 3rd. This deadline is set by the Trump administration, which wants Harvard to settle its financial obligations related to the frozen federal funds. Any decision made in this case is likely to be appealed, potentially reaching the Supreme Court, which could set a precedent for how federal funding and university autonomy intersect. In their legal filings from June, Harvard's attorneys argued that the White House's actions violate the First Amendment's protections of free speech. They contend that the government is infringing on Harvard's right to decide what to teach, express certain viewpoints, and seek legal recourse. Harvard also claims that the administration's move to suspend federal funds is unjustified and punitive, lacking any rational connection to the concerns they claim to address. On the other side, lawyers representing the U.S. Justice Department argue that federal funding comes with clear conditions, support for government policies, that universities must adhere to. They emphasize that if universities fail to meet these conditions, their grants can be revoked. Additionally, the Justice Department has requested that the case be transferred to the Federal Court of Claims, which specializes in financial disputes involving the federal government. President Trump has hinted that his actions against Harvard are part of a broader negotiation strategy. At one point, he suggested that a settlement might be possible, saying, "I think we're probably going to settle with Harvard." A White House spokesperson echoed this sentiment, expressing confidence that Harvard would eventually support the administration's vision through good faith negotiations, implying that a mutually beneficial deal could be reached. This confrontation with Harvard is just one piece of a larger effort by the Trump administration to exert pressure on elite Ivy League institutions. Earlier this month, U.S. Immigration and Customs Enforcement issued subpoenas to Harvard, demanding information about international students, and Trump has even floated the idea of stripping Harvard's tax-exempt status. Meanwhile, in March, Columbia University agreed to several demands from the administration, such as banning face coverings during protests and reviewing admissions policies, after the White House threatened to cut off $400 million in funding. However, these concessions did not fully satisfy the government, which has since threatened to revoke Columbia's accreditation altogether. This ongoing clash raises fundamental questions about the balance of power between government oversight and academic independence. Do you believe the government's actions are justified in enforcing policy conditions, or do they threaten the core principles of free academic inquiry? Share your thoughts. Should universities be subject to political pressures, or must they remain autonomous spaces for free thought and expression? Harvard versus Trump. Legal battle over federal funding freeze. High-stakes drama is unfolding in a Boston federal courtroom, and the outcome could reshape the future of academic independence nationwide. Imagine this. Harvard University is facing off against the Trump administration over a staggering $2 billion in federal funding, putting groundbreaking research and the very autonomy of American universities on the line. But here's where it gets controversial. At the heart of this dispute is not just money, but questions of free speech, academic freedom, and the delicate balance of federal power. On Monday, Harvard's legal team stepped into court, arguing that the federal government's sudden freeze of more than $2 billion in grants and contracts is not only unjustified, but also unlawful. According to documents filed in Boston's U.S. District Court, Harvard asserts that these sweeping funding cuts, which could paralyze crucial research in fields like medicine, science, and technology, were used as a bargaining chip to influence the university's internal policies. Their lawsuit seeks to overturn the Trump administration's decision, warning that allowing this tactic would undermine the independence of colleges across America. So, why did the Trump administration pull the plug? Citing violations of Title VI of the Civil Rights Act, they allege Harvard neglected to address antisemitism on campus. As a result, they claim Harvard no longer qualifies for federal research dollars. It's a move that sent shockwaves through the academic world, with dozens of universities now seeing their own federal support hang in the balance. Jody Ferris, an attorney specializing in higher education, notes, "This case is a bellwether. Everyone in the sector is uneasy, because if this can happen to Harvard, it can happen to any college, public or private, big or small." Harvard's defense is multifaceted. They point first to the Administrative Procedure Act, APA, which prevents federal agencies from abruptly changing policies without proper cause or process. The university contends that Congress has established clear guidelines for revoking funding based on discrimination allegations, and those weren't followed in this case. Countless organizations have sued the Trump administration on nearly identical grounds, with over 100 lawsuits tracked by the nonprofit Just Security, citing suspected APA violations. But that's not all. Harvard also argues there's no logical link between accusations of antisemitism and the government's decision to halt funding for life-saving research. As their legal filing puts it, the government cannot show any rational connection between concerns about antisemitism on campus and the freezing of research aimed at saving lives, propelling American innovation, and safeguarding national security. Furthermore, Harvard alleges a First Amendment violation, claiming the federal maneuver encroaches on academic freedom and private speech. They assert that federal authorities have been pressuring the university to change how it hires, admits students, and maintains records, interfering with the very decisions that universities are meant to govern themselves. On the flip side, the Trump administration accuses Harvard of failing to protect its Jewish student population. When Harvard rejected a series of federal demands, the administration's Joint Task Force to Combat Antisemitism, which spans the Departments of Justice, Education, and Health and Human Services, responded by halting federal funding. In the White House's words, "The gravy train of taxpayer funds for elite institutions that don't comply with basic standards is over." Harvard, by failing to meet core requirements, has lost its privilege to access these funds. This is where debate heats up. Was Harvard truly complicit in fostering discrimination, or is the government using a serious civil rights concern as political leverage to control academia? Jessica Levinson, a law professor at Loyola, describes the government's rationale. They're saying Harvard failed to protect Jewish students, failed to follow the law, and now faces the consequences, a loss of federal dollars. Still, Levinson and other legal scholars caution that the ultimate legal question isn't just about what happened, but whether the administration went through the correct legal steps to impose such severe penalties. The impact of this case is massive. The more than $2 billion at stake underwrites over 900 Harvard research projects, spanning everything from cancer therapies and Alzheimer's prevention to military innovations and studies on student mental health. Dr. Carrie Nadeau, whose research into preventing life-threatening allergies in children was abruptly defunded, lost $12 million overnight. "We had to suspend our work," Nadeau explains. "It's not just us, it's the families in clinical trials, the researchers we train nationwide, everyone who depends on this research." She worries most about children left without potentially life-saving interventions, a real-world ramification that goes far beyond politics. No matter what the judge decides, legal experts agree this fight won't be resolved quickly. Harvard might win round one in Boston, says Ferris, but don't expect that to be the last word. Regardless of the outcome, appeals are almost certain, and this issue could escalate all the way to the Supreme Court. And this is the part most people miss. The bigger question isn't just about Harvard. It's about the precedent. Should the federal government have the power to pull research funding to enforce compliance on controversial campus issues? Or does that undermine the independence and free expression universities are meant to protect? Where do you stand? Is the government right to make funding conditional? Or does this overstep and threaten academic freedom? We'd love to hear your perspective, share your thoughts, and join the debate below. Is Harvard being unfairly targeted? Or is this just holding powerful institutions accountable? The comment section is open.